afternoon, Pierrick. Welcome. It's great to connect with you. We are now at key number 4, which is the profession of mediators. And you wrote a very interesting article to say we need to take action to ensure that mediation is respected as a true profession. And so I look very much forward to hearing more about that. Before we do that and dive into the substance, I would like to give you the opportunity to introduce yourself.
Yes, hello Manon, and thank you for the opportunity to discuss my article. My name is Pierrick Le Goff. I'm a partner at French law firm De Gaulle, Florence et Associés in Paris, where I am involved in various areas, but some of my main areas are arbitration and compliance. Obviously, I am also involved in a broader spectrum of dispute resolution, and that's the link, obviously, with mediation. I spent a large portion of my career in-house. I have a previous background as general counsel, and during my life in the corporate world, I was quite often involved in mediation proceedings. I am also an affiliate professor at Sciences Po Law School, so I also have academic duties. And more recently, last June, I was elected as the co-chair of the International Mediation Institute, which gives me obviously another angle to be quite heavily involved in the field of mediation.
Fantastic. So you can give many different perspectives on the mediation profession.
Exactly.
What is actually the core or a key message that you want people to get after reading your article?
I think the starting point, which in a way is also the key message, is that we have a situation which is some kind of a paradox, because on the one hand, the field of mediation is very rich. We have mediators with a very diversified background. We have people coming with sociology as their major. We have people with philosophy as their major. We have commercial people, obviously. We also have legal people, lawyers. And this should be, in a way, a competitive advantage. I mean, this is truly something that adds a lot of diversity in the field of mediation. At the same time, and that's a bit the paradoxical situation I'm describing, it means that it creates some complications in terms of harmonization of the practice, of the level of experience, of the background. And one of the key aspects of the article is to explore how can we solve this, and how can we improve further towards making mediation a real recognized profession, taking also as a context the fact that many mediators tend to rely on the expertise and the experience they have gained in other professions. And in a way, mediation should also have its standalone features such that it is really recognized as a true profession.
Okay, so for you, it is that you said, well, you see a paradox. On one hand, we have a USP that we have such diverse backgrounds, and in fact, we should be able to offer a product nobody can refuse. However, we are scattered all over the place, and there are too many people who just do it on the side, like, okay, it's a nice hobby. However, we need professional mediators, full-time mediating, or in any case, full-time in the dispute resolution business.
Yeah, it's a good summary.
And what is some of the ideas that we could carry out as a dispute resolution professionals in order to get there, to make it a true profession?
I think a visible first initiative is to boost everything that is around training and education, and maybe I will focus more on education because of my academic duties. I think the educational programs should become more numerous. If you compare with the field of arbitration, for example, in the past years, you have seen a lot of universities developing master programs specializing in international arbitration. You also see a lot of arbitration competitions being organized. And this helps a lot with making arbitration a true profession. And I think that mediation needs to follow that pattern, not necessarily with law school. I mean, obviously, it makes sense to develop mediation diplomas in law schools. But as you know, the field of mediation is not reserved for lawyers, as we just said in the introduction. And you could therefore envisage also developing academic programs in other departments at universities, whether at bachelor level or master level. And I think we should also see more mediation competitions. Some are already existing, and they are very interesting mediation competitions. But I think that we need to boost all of this to make sure that mediation finds a commensurate place in the academic world.
Yes, and so you were saying that in fact mediation should be some kind of interfaculty study, so that many faculties together offer mediation, so that we have all this broad input.
Yeah, exactly, and I think that it's it's a good and it's a scientific supplement to trainings, because we know there are mediation trainings, but they take more the form of professional trainings. And I think that the difference with academic programs is that you really establish the field as a scientific field which is recognized at university level.
Yeah. And the other thing is, so besides the education, which is an important part, and that also has been discussed in many, many interviews that we did over the past weeks, and that it's really a crucial next step. Are there also things that we from the dispute resolution society, so we as mediators can do?
I think maybe a very important initiative is to continue the focus towards harmonizing practice standards, certification standards. It means that we need to be very meticulous and very careful with what are certification requirements, what is the level of training, of experience that is required to become certified mediators. That's one of the major duties and one of the major activities of the International Mediation Institute. And I think that at the same time, we also need to recognize that mediators can be at different phases in their career. We have young mediators entering the scene, and by definition, they have less experience, and we have very senior mediators. There is always, like in arbitration, some kind of a catch-22 situation where parties want and expect experienced arbitrators, but you need to start one day, and it's in a way quite similar with mediation. And I think that by having different levels of certifications and trainings based on where you are in your mediation career is also a good way to make sure that we have enough diversity in the way we certify mediators.
Mm-hmm. And that could also accommodate local differences, because if you look at many different practice standards around the world, I mean, there's a hugely different process being done in many different countries, and we all call it mediation.
Yeah, that's correct, and that's why international cooperation is very important. Cross-border collaborative effort between national mediation centers is very important. That's also one of the reasons why at IMI we have certain mediation centers who are represented in the board of directors to make sure that we draw from national expertise and national differences.
Mm-hmm. And how can IMI take this leadership, make this happen? What is necessary in order to be able
I
to do
think,
that?
yeah, I think there is first maybe the avant-gardist approach. I mean, IMI has been around for quite a long time. All things considered. As I was just explaining, there are various institutions that are part of the IMI board. We have an international footprint. I mean, we have board members from Asia, from Middle East, from Americas, from Latin America, Europe, and so on. So that helps. But I think there is another important element which gives me a good transition to another aspect I was developing in the article, which is the one around code of ethics, code of conduct for mediators. IMI has developed a code of conduct for mediators. And I think that this type of initiative is very important because any profession to be respected as a true profession needs official rules of good conduct. This is important as a matter of principle. And I think it is even more important today. When I say today, I mean 1 year almost day for day since the signature of the Singapore Convention, because in the Singapore Convention you have certain provisions which specify that settlements arising from mediation proceedings can see their enforcement refused or rejected if it becomes apparent that the mediator in charge violated certain rules of professional standards or did not proceed with the mediation according to principles of transparency, fairness, autonomy, independence, and as a result, there will be a higher attention that will need to be devoted to what are exactly the standards of good conduct for mediators. And when we talk about impartiality, when we talk about independence, when we talk about disclosure duties, when we talk about conflict of interest, there will be really a need for uniformization of the standards in this area.
Mm-hmm. In one of the other articles, the idea was launched, why not make a universal code of disclosure? In fact, it would be a top-level thing just over the code of professional conduct, because we can discuss among ourselves for a long time whether all things should be in a code of conduct. What do you think about that idea?
Yes, I think the more universal we have as an approach, the better. I think that's one of the complexities in this specific field, because it's not just the code of conduct as such, meaning establishing the standards. It's also how do you monitor the compliance with the code of conduct, which is more the discipline aspect of the story. And here you have potentially different schemes you can look at. I mean, you can have national schemes versus regional schemes. You could look at the mediation centers to organize their own disciplines. But I think the more we have a universal approach, the better we are in terms of making sure that issues of disciplines and potentially disciplinary sanctions for mediators are applied in a fair and consistent manner to make sure that facts are assessed with a same level of scrutiny, and that sanctions, if sanctions need to be applied, are applied with a level of fairness and proportionate level to the facts that are uncovered after a compliance process.
Mm-hmm. And well, at the moment we have more and more online mediation, and many trainings are fully being carried out online. Does that make a difference in, will it be easier or will it be more complicated in order to get this true profession?
Yes, I think, first of all, if I address your question, starting from the last point we just discussed, I think where I see a development is in connection with what I call the duty of competence. I mention this because quite often when you think about a code of conduct, you think about the most obvious features like impartiality, independence, neutrality, fairness, and so on. But there is an important one which you see reflected in certain codes, which is the duty of competence. Because when parties turn to a mediator, you know, they want to ensure that the mediator has the right level of competence to handle the matter. And to the extent we see an inflation of you know, online approaches to mediation, it's important to not just master mediation techniques, but also to have a sufficient level of expertise to handle the digital aspects of carrying out online mediations. It's not just a requirement that came out of the sanitary crisis. I mean, obviously, the COVID-19 situation has prompted or has accelerated the need for tools and digital approaches to mediation, but it's a more general topic which is linked to other areas such as sustainable development and maybe many other good sense or common sense principles.
So we need a code of competence. Would that maybe be something where we can all find agreement?
Yes, I mean, I think first, to reflect the duty of competence somehow in the codes, and then, we are somehow back to square one, which is, training, certification, and so on. Obviously, the more you can justify accreditation, certification, trainings, diplomas in the field of mediation, the more, you have this competence background with you to develop and carry out properly mediation services.
So to round this off, when you look at the whole 7 Keys work, or maybe one of the publications in particular, was there something that stood out for you, or something that was a real eye-opener?
Yes, I think, first of all, if I think in terms of the process and not just the contents, I think that the peer review process that was applied for the publication is a very interesting one, which is not that usual, especially with a large number of authors. And I must say, and it's in a way quite of a personal feeling, but it was very comforting and very exciting to know that 39 other authors were going to look at my draft article and my comments and give me some preliminary views, which I can take on board for the final version of the article. So just the process itself, I think, was amazing. Then I think the other amazing factor is to see, and we are again, back to our introduction, but I think that since the authors have these different backgrounds, I mean, some of them are practitioners, others come from the world of academics, others are lawyers, others are non-lawyers. It's a very rich combination of thoughts and reflection, which was also for me not necessarily a light opener, because in a way it's something that I expected, and that's why I was focusing my article on this. But it was very nice to see this in action when reading the other pieces of the book, and see that there are indeed many other aspects of mediation and mediation ideas that can be tackled.
Yeah, it's a rich landmark piece. It's very impressive to see what all colleagues together produced in fact. So, okay, Pierrick, thank you very much for this interview. I don't know whether you have some last thoughts or words or you would like to share.
Yes, maybe a last point. Thank you for giving me this chance to share it, because our articles had to be condensed, so we could not talk about all the ideas we had. But I think we are really at a phase which is a fantastic phase for the field of mediation, because a lot of progress has been made, and we can see through this publication a lot of new initiatives that can be pursued towards the path of continuous improvement for mediation. And at the same time, we are also seeing very new areas of practice for mediation, which were not necessarily considered several years ago, but which are now appearing on the scene. I'm thinking about investment treaty arbitration, mainly because I consider that one of the great advantages of the Singapore Convention is that because it's a United Nations Convention, it will carry much more weight for parties to mediation, which are either states or state entities, which is relevant not just for investment treaty mediation, but also for any mediation which arises from commercial relations, commercial contracts between private corporations and state entities, where in the past there was maybe some skepticism about mediation that was creating some hurdles from the side of state entities. And now that it's fully embodied and recognized as a United Nations Convention, it should really facilitate mediation with state-owned companies or state entities. The other area which I think is gaining momentum is the area of business human rights and dispute resolution in the field of sustainable development and everything that is linked to corporate social responsibility. We saw last year the release of the Hague rules, which are rules which were developed in the field of arbitration to make arbitration suitable for business human rights disputes. And I think that with the help of the Singapore Convention and more generally with the momentum we are seeing in the field of mediation, mediation is also going to be a very suitable avenue in order to settle disputes arising from tensions and conflicts in the field of sustainable development, in the field of what we call nowadays business human rights, and the ways through which corporations are to apply business human rights due diligence and have to take into account the human rights dimension in the way they carry out their businesses. So all of that to say that we continue to see some brand new fields which are very promising as fields of practice for mediation.
Yeah, beautiful and promising indeed to see these new emerging fields. And thank you very much for adding that. Thank you for this interview, and well, I look forward to the continuation of our talks on how to make mediation a true profession.
Yeah, thank you very much.